Hi, everyone. I know it's a little bit warm in here. They should be fixing it, but for the folks in the back, we're ready to go ahead and get started. We're webcasting, so they just needed a second to cue things up. But I'm Jamie Markham. I'm the editor-in-chief of the Duke Law Journal. And just wanted to welcome everybody briefly to the Duke Law Journal annual fall lecture. Professor Fisk will be giving sort of a formal introduction, but I just wanted to say a quick word of welcome. Thank you, Dean Bartlett, for coming, and for the other members of the faculty who are here, and then for all the students who are here as well. I just wanted to give a quick sense of the process through which we, the members of the journal, choose who we invite to give the lecture each year, and sort of what it says about what we think about the paper that you can read in the journal in the upcoming issue in December, and the lecture that you'll hear from Professor Dudziak today. Each year we receive about 3,000 submissions, and of those we accept about a dozen for publication. And then of that already select group, we get together and basically choose the one that we'd like to invite the author here to Durham to present as our fall lecture. So that's sort of a long way of saying that this is an article, and we think a lecture that we think will be enjoyable. We hope that you read it, and says a lot about what we think about it. And with that, I'll invite Professor Fisk up to say sort of a more formal introduction for our author.
Introducing speakers is sometimes a chore, but in this case it is an unalloyed pleasure. In part because I have known Professor Dudziak for a very long time. In fact, before I was a law professor, when being a law professor was really only a gleam in my eye, she already was a law professor and was a friend of a number of people, and was an inspiration to me as I started teaching myself what it would be to be a legal historian, which eventually I became. Professor Mary Dudziak is a legal historian whose research focuses on international approaches to legal history. She is, in a certain way, the dean of the School of Civil Rights History, which looks at American civil rights history through the lens of how U.S. civil rights issues were perceived overseas, particularly in Africa, but also she really pioneered a new way of looking at why American civil rights policy changed when it did after generations of intransigence, having a lot to do with the American government's concern that we, the United States, were losing our moral credibility in the world as a democracy when, in the view of many, our race relations were a stinging indictment to our claim to protect freedom and justice for all. Mary has written a number of path-breaking articles making this argument, but not only in that process of changing the way that constitutional scholars and civil rights historians understood why America changed when it did. She's written a series of works that really transform the way that civil rights historians think about what their field is and what you need to study. And so the paper that she's going to give to you today involves a lot of archival work in Kenya, which is not necessarily the place that American civil rights historians or legal scholars think that you need to go to understand the legal history of race relations, in part in the United States. She's the author of a number of eminent books, including Cold War Civil Rights, Race and the Image of American Democracy, and September 11th in History, A Watershed Moment, which was published by Duke University Press, I have to claim. She is now working on a book of which this chapter is a part on Thurgood Marshall's African journey, and then after that already has another book queued up, How War Made America a 20th Century History, both of those forthcoming from Oxford University Press. Mary received her A.B. from the University of California at Berkeley, an institution near and dear to my heart and the heart of Dean Bartlett, since we are alumna of that institution. Her JD and PhD in American history from Yale University. She clerked on the Fourth Circuit for Judge Sam Ervin, himself an interesting character, and was a professor at the University of Iowa Law School and History Department for a number of years before joining the faculty at the University of Southern California, another institution near and dear to my heart, so it's very nice to have her here. And she taught last year, most recently, at Harvard Law School. It's a pleasure to welcome Professor Dudziak.
Thank you so much. Thank you, Catherine, for that generous introduction. Thank you, Dean Bartlett, for being here and for all that you do to make things like this possible. I'm delighted to be here. I did spend a wonderful year in North Carolina as an Ervin clerk a while ago. And I'm delighted to be at Duke, which is thought of as a center of civil rights history. So for the law students, if you're not making your way out of the law school, you should know that elsewhere on campus there are wonderful things going on for you to know about in civil rights history. Special thanks to Jamie Markham, to my editor, Stacy McGavin, to the entire Duke Law Journal staff, not only for inviting me to join you this afternoon, but especially for making a place in your journal and in law reviews for narrative history. The story I want to share with you today is a story that has both been told many times and never been told. The story of Thurgood Marshall and the Kenya Constitution was one of Marshall's favorite stories. He would talk about it with his law clerks, with his friends. When Justice Rehnquist eulogized Thurgood Marshall in the Supreme Court chambers after his death, an entire paragraph of his speech was about Marshall's work on the Kenya Constitution. Now, there are bits and pieces of the story, mostly based on Marshall's oral history, that appear in biographies. But the fuller story, the basic, nuts and bolts archival research, and thinking more broadly about what this story might mean to our understanding of Marshall and his life, and of the role of American law and lawyers around the globe, really has sort of passed American legal history by. Now, there are some practical reasons for this. Even if you didn't want to go to Nairobi, there's research that can be done in the U.S., but records that in the U.S. that detail the outlines of the story aren't in civil rights archives or Thurgood Marshall's papers. They're in U.S. State Department records pertaining to Kenya. The most important documents that I talk about in the paper aren't in the U.S. at all. They're in England, in British colonial records. The story is filled in with newspaper accounts from Africa, from different African countries, from England, from U.S. and American and African American papers. And it's in these sources, sometimes especially these newspaper interviews he did at the time, and arguments he made in committees that are captured in these British documents, that we can hear Thurgood Marshall at the time speak about what he thought was at stake in Kenya and what he hoped to do. But there's another reason that stories like this have not in the past been pursued. American legal history has proceeded within the frame of American history, the narrative bounded by the boundaries of the nation. American stories happened within this frame. As a figure in American civil rights history, Marshall surely belonged within that national frame. Excursions outside were departures from the real narratives, perhaps vacations from American legal history, not treated as really sort of serious parts of the story. But American history has changed. The writing of American history has changed. The borders have come off. And this means that not only are many scholars looking at the way that the outside comes in, the way international events affect what we previously conceptualized as domestic stories, But also, we can see that the story of America goes other places and does other things that our earlier paradigm did not allow us to see. So this is just a little part of a broader way of reconceptualizing the way we think about not just American legal history, but sort of how American stories exist in the world. Now, this particular story isn't just an American story. And it's not comparative history, where two stories are sort of alongside of each other and we look for comparisons. When I went looking for Thurgood Marshall in the archives, I ran into another story, and that happens so often when you do archival research. You have this idea in mind, you go looking for the records, and then you just start running across other things, and at some point it hits you over the head that you've come across a narrative that is part of your story and you have to take it into account. So I'm looking for Thurgood Marshall in the Kenya archives, the U.S. State Department archives having to do with Kenya, and I keep running across other stuff. And there was a story there. These groups in Kenya are fighting with each other about things that they care about, property, political power, and they're fighting not with weapons, but with constitutional clauses. Interspersed with records about Marshall are all of these proposals from one group saying, here's the model of a constitution we want, here are the clauses we want, and then from the white farmers saying, no, we want a US-style constitution with a Bill of Rights and judicial review. And I finally figured out that I wasn't writing about Thurgood Marshall goes someplace and does something, but I was writing a story about Marshall, and I needed to also write this story about what's happening in Kenya, and that these two stories end up in the middle of each other. So this is the way I think of transnational history, that there are these two narratives that they intersect, they unfold alongside of each other, they get mixed up with each other, they get entangled together, and they become, at least for a time, part of each other's stories. And in order to understand Marshall, I had to come to some understanding of what was happening among these groups in Kenya. So let me say a little bit about what do we learn from the story. So do the argument up front, and then I'm going to tell you the story. Now, just about Marshall, many people wondered, well, did he have an impact? What did he do? And just the bottom line is, yes, he had an impact. His impact was valued. His full Bill of Rights was not adopted. Parts of it were, but his participation was thought to be so important by the nationalists that when nationalist groups splintered into two, both groups wanted him back the next time they had a constitutional conference. And his work on the Kenya Constitution was referred to by the British colonial secretary as an important contribution and something to be considered as they went forward as he brought the Constitution to a close. So it was remembered and valued by others at the time. Well, what do we learn anything about constitutionalism and constitutional politics? There's so much interest now in comparative constitutional law and looking outside the U.S., but American scholars, if they look at Africa, don't tend to want to look at Kenya. If we're looking for law in Africa, where do we want to look? American scholars like to look at South Africa. South Africa looks like us. There's a successful constitutional court. We can find judges engaging in judicial review in a way that's familiar to us. And so when we do comparative law, comparative constitutionalism, and when we look to Africa, that's the story we look to. Kenya is thought of as a place, as sort of a land of constitutional failure. There was a constitution that was enacted at independence in 1963, but we don't see the story we're familiar with, this iconic text that is then set in stone, enforced by independent courts, that is then able to hold back the forces of authoritarianism. That didn't happen. And so the story of constitutionalism in Kenya is thought to be a story of failure. There's nothing to learn, so we don't go there? Well, I want to suggest that if we're looking for a story that looks like America, then we're missing a story about constitutionalism and constitutional politics that's important and valuable. And here's what it is, and then I'll sort of show you. In Kenya, Kenya in 1960 was a country moving towards independence in a context of a tremendous history of violence in Kenya and a potential for violence throughout Africa. And that's sort of a bottom line that's so important to sort of think about in this story. Kenya hadn't been a nation before. Kenya was in East Africa. It was the boundaries of what is now Kenya were set by colonial powers when the Europeans divided up Africa in the scramble for Africa in the late 19th century. So then the British then encouraged whites to settle there, encouraged Asians to come and work on a railroad that was set up. And so you have a multiracial population in Kenya. Blacks were then forced into labor on white plantations, and you had a very brutal colonial regime. Then a violent resistance movement in the 50s, the Mau Mau Rebellion, which was then put down through torture and detention that's been detailed in two important new books, including Carolyn Elkins that just won the Pulitzer Prize. And so you have this history of just terrible violence in Kenya. And Kenya is just emerging from that in 1960. The colony was just emerging from a state of emergency, but terrible restrictions on political organizing were still in place. Now, in 1960, what happens in the rest of Africa? 17 nations become independent in 1960 alone, but also what happens in Africa. The Congo crisis in the former Belgian Congo, and so often right after that, in Kenya, everyone talked about Kenya as being a potential another Congo. There was great fear that violence would erupt in Kenya. The Sharpeville Massacre in South Africa happened in 1960. And so it's in this context of past violence and repression in Kenya, and this reality of violence throughout the continent. And then what happens? The process of constitutional politics enables these groups that had literally been killing each other to come together at the table and to battle, not with guns and knives, but with constitutional clauses. It doesn't result in an iconic text enforced by independent courts that's set in stone forever. But what happens in Kenya is that there is this constitutional bargaining that begins in 1960 and happens over a period of 3 years, and you have a peaceful transition of government, and what you don't have is what happens in the Congo. So essentially the argument that I'm making is constitutional politics play a role here. They play a role in enabling people to battle with each other and help this colony transition to independence. That's a story about constitutional politics. That's a story about what constitutional politics can do. It's a story that we miss if we only look at the fact that we don't have this American-style story of an icon sort of set in stone, enforced by. I'm happy to talk more about how do we think about constitutionalism if we don't have independent courts. You know, later if you want to, there's some important new work on that by other scholars. So that's part of the story. Now, but let me walk you through Thurgood. Well, let me walk you through it. So as Thurgood Marshall is sort of approaching this, well, let me tell you where Marshall was in his life. Thurgood Marshall, in the 50s, became an icon in the United States, was sort of crowned Mr. Civil Rights, was on the cover of Time magazine. So it was in the 50s when he was victorious with Brown versus Board of Education that he really emerged as this major figure within the United States and was associated with the Brown decision. Now, by 1960, he was 51 years old. He had been working for many years, in the civil rights movement, but he was starting to feel that it was time to move on. He felt he was aging out of the movement, and as the story would develop, in 1960, the movement itself would change direction. And the students who then sort of took leadership in the movement through the sit-in movement and nonviolent civil disobedience, they looked at people like Marshall as these sort of old fogies who were holding them back. Marshall was in this moment when he felt that he, what was his role, what was his place, just as others were saying, we don't like your strategy anymore. So he had won the formal legal battle with Brown, but very little school desegregation had happened by 1960. It was unclear how long that would take. The NAACP and the Legal Defense Fund were dealing with anti-subversive charges in the South and other kinds of harassment, making it difficult to litigate. So there were a lot of frustrations in his role as a civil rights lawyer. We know he would end up being a Second Circuit judge, Solicitor General, the first African-American justice on the Supreme Court, but he didn't know that in 1960. Instead, he wanted to be a judge, but he thought he'd never get confirmed because Southern Democrats would block his confirmation. And in fact, when he was appointed to a recess appointment in 1961, it was strung out for a year until he was finally confirmed. So that's Marshall in 1960. And he's invited by Tom Mboya, a nationalist leader, to go to Kenya and help nationalists as they're negotiating on the Kenya Constitution. And this was going to be the first time that Africans were going to be at the table working with the British on a constitution for Kenya. The stakes were high. An anonymous letter was received by the colonial government in the lead up to the meeting that said, "Dear Sirs, after 10 meetings, 2,500 of us have decided that if you give the Africans equal voting power as the Europeans in this country, we will blow up everything in Kenya. Then the African can start at the beginning, the same as we did." A woman wrote to her mother in England, "Everything here is hanging on this conference, and whatever happens, I expect it will result in strikes and riots at this end." Marshall then goes to Kenya and immediately encounters the forces of colonialism. He goes to a meeting in Kiambu, which is outside of Nairobi, and the way they had to hold political meetings was, he says, there were 2,000 people out in a field, and the leaders were going into a building. And basically the permit that they had for the meeting, the leaders could go in the building, and the rest of the members of their political organization had to stay out in a field. So Marshall starts to go into the building. And I'm going to tell you the way Marshall tells the story, and Marshall was a great storyteller, and everyone tells me that he liked to sort of embellish the stories. But this is something that did happen. It's Marshall's version of telling a story of something that did happen. So as he's going into the building, the colonial officer comes up to him, and he introduced himself very politely, like the British always are, and he said, "What do you propose to do?" I said, "I'm going in there. That's what I came here for, was to talk to these people." He said, "Well, you can't go in there." I said, "Why?" He said, "You don't have a permit." And Tom Mboya spoke up, and he said, "Why, of course he has a permit. We got one last week." He said, "Yes," and it was revoked yesterday. At that point, Marshall said, "I started to be loud and boisterous and get arrested, and suddenly it dawned on me that if I was arrested, I'd be searched, and I had money and paraphernalia and stuff from Mboya and others in my pockets, and if I was caught with that, I would really spend the rest of my life in jail." Instead, he said politely to the district officer, "Of course, I understand, but before I leave, I wonder if I could say a word to these people out there." They said, "Nope, no speeches." I said, "I'm not going to make a speech. just let me say one word of greeting. He said, all right, just one word. I said, okay, and I jumped up on top of the station wagon that Mboya was driving, and I looked over the crowd, and they all recognized Tom Mboya, and I guess they knew who I was, I don't know. Well, I looked at them and just shouted out real loud one word, Uhuru, and pandemonium broke out. They all crowded and cheered and everything, and the district officer was really mad as all get out, and the reason was the word Uhuru means freedom now. Not tomorrow, but freedom right now. And he said, I told you not to, and I said, but I didn't say but one word. People have expressed skepticism about the car part of the story, but I have newspaper reports he was barred from a meeting. This certainly did happen to him. And this experience clearly had an impact on Marshall, helping him to see what it was that Africans were experiencing. Marshall held a press conference in Kenya where he told the press, independence and freedom for Kenya was due right now. He understood that the colony had reached a critical juncture. These people have had it, he wrote to his wife, and they are not going to take it anymore. In a later interview, he warned of a new uprising in Kenya that nobody can control any more than they can control the Mau Mau. He was afraid that a revolt might occur if the Constitutional Conference ended with what the Kenyans thought was an imposed constitution. This new group throughout Africa know exactly what they want. He said, they want independence now. Tomorrow is too late. So that's the lesson he learned from Kenya. He then goes to England with the African nationalist group he's working with for the Lancaster House Conference on the Kenya Constitution. And this was really an extraordinary thing. He was the only person there who wasn't either British or, or from Kenya. And one British man writes into the colonial secretary and says, what are you people doing? Don't you know he's a member of the NAACP and they're a bunch of communists? Murray Kempton, a New York Post columnist, I don't know about his politics, actually, said that Marshall's participation was one of the most extraordinary events in colonial history. He said, there's no record in diplomatic history of a private citizen of the United States sitting at a British conference whose subject is crown colonial policy. There is a romance, he wrote, in the image of Thurgood Marshall, the product of segregated schools, a child in a border city welcomed as a distinguished American lawyer by the British colonial secretary. He seems to represent the only revolutionary force we have in this country, and it is suitable for export all over the world. Now, then at the conference, there's a controversy about advisors that I'm not going to take you through, but the bottom line was that initially the British were skeptical. Does this guy know anything about Commonwealth constitutionalism? And the way this controversy over advisors worked, if Marshall wasn't there, they wouldn't have been able to broker a solution. And because of that, they end up saying, basically, thank God for Thurgood Marshall. So because of this complication that you can read about if you're interested, they end up sort of being so happy he ended up being there. Now, what then happens at the meeting is the most important issue at the meeting was something that Marshall wasn't directly involved in, moving towards what was called a common role democracy. They had in Kenya, in the colonial legislature, reserved seats. The whites get a certain number, the Asians get a certain smaller number, the Africans get a certain smaller number. And that was a way of giving a certain amount of political power to different racial groups. And the British basically signed on to the idea of Kenya moving towards what was called a common role democracy, where there were no longer any reserved seats, so it would be majority rule. This was a big deal. Now, if you move towards majority rule, then the big question was, how do you protect the rights of minorities? And so that put the issue of minority rights front and center, new important question, and that was Thurgood Marshall's job, to write a Bill of Rights for Kenya. Nationalist leader Ron Nagala said the best form of safeguard for all races was not reserved seats, but was a Bill of Rights enforced by an independent judiciary. And he said, you know, look, we've got Thurgood Marshall, who's got an international reputation as a guy who's protected minority rights, and he's writing a Bill of Rights, and so don't worry about the fact that we're going to have majority rule, because rights will be protected. Now, Marshall then writes a Bill of Rights that he submits to the conference, and it's not a simple American transplant. Instead, he writes a forward-looking Bill of Rights, including rights that have never been embraced in American constitutional law. It seemed to embody pragmatic solutions for Kenya and also an idealized vision of what rights could be. It began with a preamble, and so he puts down his most important principles in the preamble, and they are about equality, that all persons are equal before the law, and it forbade discrimination on the basis of race, color, sex, religion, and other factors. It proposed rights to freedom of religion, speech, and press, the right not to be enslaved or deprived of liberty, and the right to vote. It also includes what we would call social welfare rights that are unfamiliar in the American context. Rights to health, education, and welfare, including the right to work, which would protect, quote, just and favorable remuneration, ensuring an existence worthy of human dignity. Similar provisions guaranteeing a living wage, of course, have later become law in some American cities, but haven't become national U.S. law. In writing these rights down, Marshall wasn't making this all up. He was actually drawing from other templates. And he was drawing from the Constitution of Nigeria and the Constitution of Malaya, which had recently been enacted, and those constitutions drew language from the Universal Declaration of Human Rights. Now, the focus at the conference turns quickly to property rights, and these broader rights don't get discussed at the conference. And the broad social welfare rights don't make it into the final text. But that's I think it's sort of an interesting indication of what Marshall would do as a framer. That's actually not so much the focus of this article, but it gives us an interesting window of Marshall as a framer, that he would write these broad social welfare rights into his Bill of Rights for Kenya. So the battle at Lancaster House ends up focusing on property. And the reason is because in Kenya, what had happened was you have the most valuable land in Kenya was owned exclusively by whites. That was a colonial policy. It was called the White Highlands. And these whites then regarded this property as theirs, and they thought those property rights needed to be protected. Many Africans thought that they had lost their land and their livelihood, and their principal idea was there needs to be land resettlement and land reform. And so the property ends up getting focused around the issue of the takings clause. And Marshall wrote a takings clause that basically what would be familiar to us, that you can't take private property without just compensation. This clause later gets modified to include a right to appeal a taking directly to the highest court in Kenya. You don't have to go through a district court. And by the way, once you can do that, who's going to decide the dispute? In 1960, there was one African lawyer in Kenya. The judges they would call them Europeans. So it's basically putting compensation decisions and takings initially in the hands of whites. So this is something that Marshall is a part of crafting this clause, but also the nationalists think that having this clause is good, but the details over the clause all of a sudden become a problem at the conference. an argument breaks out about what kinds of public purposes can land be taken for, only to build a school or to redistribute land to somebody else. I mean, that's basically the problem. And because the issue arises quickly at the conference, because the British government signs on to the idea of majority rule basically more quickly than others had anticipated, no one had worked out their positions ahead of time. They hadn't worked it out with their constituencies back home. The Africans basically felt that they were being forced into a position of adopting a land reform policy on the spot, something that they simply weren't in a position to do. And so the meeting is stalled, and the acting governor in Kenya, meanwhile, says, you know what, things in Kenya are not good. There is growing sources of unrest among Europeans. We're afraid a band of hotheads may do something rash, which will spark off a rash of racial clashes. So they think they have to bring the conference to a close. They're not able to resolve this, and they need to send these folks back home so they can deal with their constituencies and resolve the growing tension. Later, a land buyout scheme with World Bank involvement would take the pressure off property rights and essentially take this issue off the front burner in future constitutional negotiations, which would then turn to other matters, especially ethnic federalism. The final Bill of Rights would contain a takings clause, a long elaboration of the kind of clause that Marshall had written, but again, not the social welfare rights. But before work on the Kenya Constitution could be completed, a call from home takes Marshall, back to New York. And the call came because students had sat in Greensboro, North Carolina. And basically, overnight, the sit-in movement had exploded. And the question then was, what do the lawyers do? And there was an immediate problem. What do the lawyers do about this? What are the legal arguments we use? And is this a smart direction for the movement? They had that kind of discussion. And Marshall wasn't happy that things were going in this direction. So he ends up continuing to work on the Constitution and then flying home to take care of things at home. For the nationalists, when they returned home, the question was whether they had gone too far in compromising with the British. Their participation had been a sign of progress, but within their communities, was it a sign of collaboration? When Tom Mboya and others were met at the airport in Nairobi, they were met by thousands of Africans. The new constitution would not last, Mboya told the crowd. The struggle had only begun. And so they were using this position they had taken as the beginning to continue to negotiate towards independence. They proceeded to African Stadium where 25,000 people gathered. And then they asked the crowd, if you support the stand we took on the Kenya Constitution, raise your hand. And around Africa Stadium, nearly every hand was raised. And so when we think about constitutional politics, I think this is a moment of constitutional politics, this sort of signing on to constitutional negotiations. Kenya's first attempt at democracy was, of course, fraught with difficulties, and rights would have little meaning for Kenyans by the time Daniel Arap Moi succeeded Kenyatta as Kenya's second president in 1978. But Thurgood Marshall remained proud of his work, of the work he did in Kenya. The Kenya he remembered was the Kenya of the early 60s. The Kenya Constitution was better, he thought, than the original U.S. Constitution had been. The Bill of Rights in the U.S. Constitution was a set of amendments. In the Kenya Constitution, it was there from the beginning. And then one of the things that he said that I don't have time to sort of go into in detail, but he says in his oral history, that, to my mind, is really working for democracy. When you can give the white man in Kenya when you can give the white man in Africa what you couldn't give the black man in Mississippi, it's good. That's how he's remembering his work as working towards democracy. And there are many ways to read this. And one way to read it is he's doing for others what haven't been done for his own people. But another way to also to read it, which is compatible with that reading, is that it helps us to think about law in the context of violence. There would be much violence in Africa in 1960, and many worried that Kenya would become another Congo. But the news from Kenya was that that didn't happen. That warfare in Kenya happened, but it happened in the context of fighting over the Constitution. Marshall had to know that when he worked to protect the rights of white landholders, he was entrenching, at least for a time, an historic injustice. It seemed to matter most to him, however, to keep these parties talking to each other, and in doing so, and to do this required a document that all of the principals could live with. What resulted was not a fully formed, ideal, democratic, American-style constitution, but was a path left open, a way to continue working towards democracy. Thank you. Yes.
In your article, you mentioned several times that at the outset of the meetings, Marshall was seen as a champion of minority rights by both the British and the African nationalists. I found it interesting that they would immediately recognize him as a champion of minority rights for the white settlers, as opposed to just say a champion of African American rights. We'd be more interested in the African side of it as opposed to protection of privileged white settlers. I know there's a lot about what your thesis goes to, but I'm surprised to recognize that at the very beginning rather than towards the end.
Yeah, that's an interesting point. So the way that because that's the way he was talked about, rather than conceptualizing him, and that's also how he would see himself, rather than conceptualizing him as standing for the rights of blacks. And so he's going to pursue the rights of blacks wherever that takes them. And that might include, let's enhance black power at home, in African countries, et cetera. It might mean a different strategy, right? And in fact, he would end up being at home a critic of the Black Power movement. But he was, you're sort of pointing out something about how ideas travel and the way that he comes to be understood and conceptualized, not as standing for rights conceptualized in this sort of identity-oriented way, but instead representing a certain sort of normative principle of minority rights. That's how he was regarded. One thing that I don't know how to separate out is that's also, and this is what I do in my earlier work, my Cold War Civil Rights, is by 1960, the U.S. government had been spending years and a lot of money promoting a particular story about race in America. Because, of course, the story about American race discrimination was known and was all over the world, newspapers and TV screens. And every time there was a problem like the Little Rock crisis that happened in the 50s, it had a terrible impact on U.S. prestige around the world. And the way the story is conceptualized in American information materials disseminated around the world was in the context of minority rights, and not a more sort of identity sort of politics. But I don't know if that's why the Kenyans talked about it that way. Mboya also had been in the U.S. a lot. He was a labor organizer and had strong UAW ties. And one really interesting part of the story is actually, I always, if there's any graduate students, boy, do I have topics for you. Tell you where the records are. Anyway, there's this wonderful relationship between him and A. Philip Randolph that develops. And so he had actually been in touch with U.S. civil rights figures even before he got to know Marshall, and maybe that's how he came to think about it that way. Yes?
This happened at seems like a very transitional point in Marshall's career, and it seemed fairly unusual for someone who becomes a judge to actually have played a role in framing a constitution. Do you see any evidence, direct or indirect, that this experience impacted how he approached the U.S. Constitution?
Well, that's the sort of thing. I'm very picky as a historian about what kind of arguments I'll make. And you can sort of speculate, but I'll never be able, unless I find something I haven't seen, I don't think I'll ever be able to make an argument that this equals, that particular line of argument or thinking. Instead, I think what we can see from Marshall as a framer is, he's sort of stepping outside the U.S. civil rights context and outside of battling over school desegregation and the other matters that were on his plate at the LDF. And he's saying, okay, what rights should there be? And I actually want to write just sort of a separate essay that substantively takes up Marshall's Bill of Rights and then sets it in the context of his jurisprudence once he's on the court, looking at his dissents, for example, and looking at issues like poverty rights. But I think we might be able to, we can see in the Bill of Rights, the parts that didn't go anywhere, him unconstrained in some ways. I mean, in some ways there were constraints, because I really do think the property clauses are part of the constraints of the situation. I mean, just as I'm answering you, I'm thinking, am I making arguments that are inconsistent with each other? But anyways, he's making arguments that are constrained by the politics of the situation, wanting to keep everyone at the table. And he knows that there are limits to what he can do in order to keep everyone at the table. But even within that context, he's being quite imaginative, and maybe what the boundaries there are what has been done in other African countries, and what do I like that I'm finding there, and then he builds it in. So I think what we're seeing, what we can see is him thinking about sort of broad, sort of substantive rights. But I don't want to make a causal argument, because I think I would be about he did this and so therefore he wrote this case that way. I think that would be just wild speculation. Yeah.
You started by contrasting Kenya with South Africa experience. And of course, in South Africa, by the time Mandela was released, you had a cadre of lawyers. Chaskelson, Goldstone, Didcot, and Meyer among the whites. You had Dullah Omar and Suraj Desai. And you had, therefore, mechanisms that could ensure this transition. In Kenya, Kenyatta was still in jail when Marshall showed up, having been sentenced to his 7 years. The British had killed 15,000 people, and there was one African lawyer, as you mentioned. In such a circumstance, could a constitution modeled on anything that Thurgood Marshall might bring ever succeed in having a role in constructing a government that would operate along lines that the folks in this room would find familiar?
Well, I think,
Point,
yeah, that's a great question, and I think part of the answer is it depends on how essential courts are to constitutionalism. There's a wonderful new article by Kwasi Prempeh at Seton Hall in the Tulane Law Review that basically critiques the argument that Africa is a region of constitutions without constitutionalism, and says we focus too much on courts. And instead we need to think about structural constitutionalism and the way that constitutions can be, that we can see successes in constitutionalism that happen, he doesn't really frame it this way, but the way I would say it is outside of courts. Just an example is, I think, Kenya now, where you see, Kenya now, the courts are not independent. The courts are widely considered to be corrupt. And having independent courts is an important platform of constitutional reform. But you've got, I would argue, a new round of really important constitutional politics working in Kenya right now. What's being enforced is presidential term limits, and that's actually really important. You can see things in some countries like presidential term limits, like multi-party elections, recognition of some structural features of a constitution. And how does that get enforced? Right now, if you talk to people in Kenya and you ask, well, do you think the current president, what would happen if I asked people in Kenya when I was there, what would happen if the current president decided to stay in office past the end of his term? And the answer is everyone would riot. Okay, and so what you have when they have another constitutional election, the next presidential election, there are going to be competing platforms of what the Constitution should be, because they've been in the middle of rewriting, and presidents run for office on the basis of bringing the new Constitution forward for a vote, and here's what it should look like. So what you have is an engaged populace, and if there's ever any form of actual working popular constitutionalism, Kenya's where it's happening, because the enforcement mechanism in Kenya is an incredibly engaged populace who will riot if certain constitutional forms aren't respected. Now, that doesn't give us, let's pay attention to this subclause of Part A, and there are serious problems in many areas, including speech rights, not as bad as some other countries. But again, I think one of the things that helps protect speech rights to the degree that they're protected is this engaged populace. So there are ways of seeing constitutionalism operating and seeing it function that don't rely as on an independent court as being an enforcer. That's the way we usually think about it, and I think that it causes us to miss some important stories, both historically and now. Yes?
You spoke a bit about the history of the land reform movement. I'm wondering how you feel about the future of land reform after George and Dugu's report was released exposing the vast irregularities within the current land title system. If you think that the recent decision from this summer, which said that this land should actually be reallocated to the public and to the hospitals and schools, or if you think that's needlessly inefficient and very expensive.
Here I want to sort of say I'm a historian, the issues of land continue to be tremendously important, and one of the difficulties in Kenya politics is sometimes it's even difficult to pull out the history because it's so politicized and people don't want you to remember. Looking at, for example, other countries like Zimbabwe and even South Africa, the issue of land and justice is just a continuing problem in Kenya and other countries. How that gets resolved, I just am not. I'm not sure I have a good answer about what's going to happen on the ground. But I do. The way I sort of think about it is I've sort of come to think about it as the problem of having at one point. At this point in time, they collectively entrenched an historic injustice. And so in some ways, the problem now is how do you take account of an historic injustice and how do you remedy it? And that's tremendously important to moving forward.
If people have additional questions, we'll have a reception just out in the loggia right here after the lecture. But I hope everyone can join me in thanking Professor Dudziak for